Hello guys, this is Olayeni Dear Corolla Daniels, popularly known as Dear Co Spectre, and welcome to another episode of Dear Co Talks Law. On today's episode of Dear Co Talks Law, we will be talking about land law, particularly the nature of the members' rights when it comes to customary land tenure system in Nigeria. But before we go straight into what we have today, if this is your first time of coming to my channel, please make sure that you click the subscribe button and also make sure that you click the notification bell so that anytime I release any video which is going to be of interest to you, you are going to be one of the first set of people to watch that particular video. And also make sure that you follow me on LinkedIn at Dear Corolla Daniels. Thank you so much. Now, today's class will be talking about the nature of members' rights. Do not forget that in my last series of classes, if you have not watched my last series of classes, you are going to see currently rolling on your screen the playlist to my land law videos. When you watch my land law videos, there was a particular lecture where I talk about the 4 things to know about customary land tenure system. And I told you that under customary land tenure system, an individual owns land, but it's very unlikely you have it more in a family setting. So the land is vested in the family other than an individual. Do you understand? It could be in a family, it could be in a community. And I explained to you using what Obasanjo said as regards the Yoruba system and all that. You can watch that video. It's a very interesting video for you to watch before you continue this lecture. Because in this particular lecture, we are talking about each member of a family and what right they have to the land that has been owned by the family. But let me give you a little illustration before I continue with this lecture. Now, let's say that this is the land that is owned by the family. Now, this land is situated at Lekki, for example, and the father and the mother that own this land, they are now deceased. But before they died, they gave birth to 3 children. 1, 2, 3. Now, do you understand? The people who are the owner of this land at Lekki, they are now deceased, which means they are now dead. And then when they died, they gave their land to their 3 children. 1, 2, 3. Now, each of these 3 children gave birth to 3 additional children. 1, 2, 3. The first thing that we need to understand is that when it comes to this family now, because these people are deceased, these are the principal members of each of the family. I told you that we are talking about customary land tenure system. This land does not belong to A, does not belong to B, does not belong to C. This land belongs to the family, the 3 of them. Do you understand that? Now, when we are saying that this land belongs to the 3 of them, another thing that we need to look at is that the 3 of them cannot administer the land at the same time. Therefore, there has to be somebody who is going to stand in a position of responsibility while administering every right and duties in relation to the land. And who would that person be? That person will be known as the family head. So let us make the family head this person. This person is the family head because the person came first. Let's say the person is the eldest. Therefore, the person is regarded as the family head. Now, the next question is, the other members of this family, what will be the rights that they would have when it comes to family head? I have already made a video as to the distinction between a family head being a trustee under the customary land tenure system and being a trustee in English law. I made a distinction between the both of them in my video part 1 and 2. Please make sure you go and watch that video, because in that video I also discussed the rights of a family head in relation to family property. Do you understand? The fact that he might be the one having the responsibility to discharge the rights and duties in relation to that property, but the property is not vested in him. The legal estate is not vested in the family head. He can sue and all that, but still the legal estate is not vested in him. I already discussed that when it comes to the distinction between the family head being a trustee under the land customary tenure system and that under the English law. Please make sure you watch that video. I've also kept it in the description box below. But now, our question for this class will be, what will be the rights of these people? B here, who is not the family head, but is a principal member, because, you know, she's part of the children of the main owners. And then C here, what would be their rights in relation to this particular land here? Do you understand? And also, these three children, each of them, what will be their rights in relation to this particular land here? Now, this is the juncture where we go to my notes. Now, while discussing my notes, a member of the family is entitled to be allotted a portion of the family property for his exclusive use and enjoyment. He may build his house on the land as well as farm on it. Once the land is allotted to him, he owns the land to the exclusion of any other member of the family. His status is not, however, that of ownership rights, but in actual fact, he stands in position of a tenant on the land, and the only difference is that he does not pay rent and his tenure is not determinable. His children would inherit the land after his death. The family may, if it is not convenient to them, reallocate another portion to the children, but it is clear that his right to live, farm, and enjoy the allocated land cannot be disturbed even by the family. Now, this is very, very interesting. We are talking about this land here that is at Lekki, yeah? And now, what we just read is that although A is the family head, B and C have right to this land. Now, the kind of right that they have is not right to ownership. They do not own all the land. No. The land is not vested on B, neither is it vested on C, neither is it vested on A. It is vested on the, let us say, Olabisi family, for example. Let us call this family Olabisi. So it is vested on the whole of the Olabisi family. It is not A or B or C. But now, when you are now talking about the whole of the Olabisi family, which is ABC, we now have to look at what right does A have, does B have, does C have. Now, when we are talking about B and C, who are normal members, don't forget that A is the family head. When we are talking about B and C have right to be allotted, B, a part of the family land. Also, C has a right to be allotted a part of the family land. Do you understand? Now, that allotment is not that he is the owner of the land. At the same time, it looks as if, since he's not the owner, it looks as if he is the tenant. But still, he's a tenant that doesn't pay rent. And his tenancy is not determinable, which means that his tenancy never ends. When you're talking about tenancy, leases and tenancies, you know that when you go to collect houses, if you're a student, you collect houses 1 year rent and all that. But we are talking about tenancy in this case. The tenancy here is not determinable, which means it never ends. The portion that has been allocated to him is his. Nobody's taking it away. Do you understand? Nobody has the right to take it away. Even the family members cannot take it away. So it is B's right to this portion, but B is not the owner of the portion. The owner of the whole land is on the family. B has right of allotment, right to get the land, but not right to own the land. His right is right to possess the land, and that right is only limited to him while he is alive. When he dies, we are going to see other rules and then ask ourselves, what happens to the land when he dies? Let's go on with my note. Now, the member may therefore go to court to compel the head of the family to allocate family land to him. This was held in the case of Amodu Tijani versus Secretary of Southern Nigeria. In some cases, like in the case of Ajobi versus Oloko, the court ordered a petition where it was discovered that the family head had refused to allocate land to some family members. Now, you see, when it comes to something like this, this scenario is so simple. Do you understand? But when we have scenarios like this man married about 4 wives, so you have 1, you have 2, you have 3, and each of these wives have different children. Now each of those children in relation to the 4 wives are principal members, and the head of the family came from here. The head of the family might not say, hey, so my father married more than 4 wives, Abi. I don't like the way the children of the 3rd wife and the 4th wife used to behave, therefore I will not allocate land to them. That's their business. But each of the children of the 2nd, 3rd, and 4th wife, have rights of allotment of that land. But because the family head here is saying, I don't care, you guys can do whatever you want to do, it's none of my business. As far as I'm concerned, I am the Olori Ebi of this house. I am the family head, and because I'm the family head, I can do and undo. According to Amadu Tijani versus Secretary of Southern Nigeria, no, family head, sir, you cannot do and undo. Every member of that house has the right to get allotment. That is what this particular case has told us. And secondly, in the case of Ajobi versus Oloko, where it seemed as if the family head was adamant and said he wasn't going to give other members of the family the right of allotment. That means that they were not going to have their own land where they can possess, at least for their lifetime. The court ordered a partitioning of the land, which means it destroyed the land from being a family property and then partitioned the land that everybody, take your portion and go. There is no longer family property. Now what we have now are individual properties that has been partitioned to different people. Do you understand? Which means that the whole family property thing has been destroyed. Do you understand that? And now let's continue with more rules in my notes. Now the member's rights is only limited to land allocated to him and is not expected to enter into or take over land that has not been allocated to him, as has been stated in the case of Lewis versus Bankole. The member cannot sell or dispose of the land allocated to him from the family property, as he has only the right of use. A member cannot alienate his own portion of the land to a third party or dispose by will to his children or any other person, because nemo dat quod non habit. You cannot give what you don't have, and definitely you cannot do this without the consent of the family, as was held in the case of Akeju versus Suwenu. Now, he cannot also use the property as collateral for his personal debt, and this was also held in the case of Jacobs versus Oladuni brothers. Now, there are certain rules that we have seen here. The first thing is that where you have been allotted land, my brother, the land that you have been allotted, stay on it. Don't go over to land that you have not been allotted because you have no right to that land. The person who allots land is the family head. When the family head has given you a land, my brother, stay there. Don't move out of your land. We have seen that through. The second rule, my brother, you see that land that you have been given, you can't sell it. You don't have the right to sell it. Number one, that's to a third party. Neither do you have the right to keep it in your will as part of the properties to give your children. I told you when I was explaining from the initial onset, I told you that when you are talking about the right that the member has, the right the member has is a right of allotment, which gives him a right of possession. The possession only lasts as long as he lives, as the sort of tenancy which he has on the land, because he's not the owner, is not determinable, which means that his kind of tenancy never ends. Do you understand? It only ends when he dies. Now, when he dies, the family can say, omo dada na omo mani say that this man has very good children. Let them continue living on the land. The family can give the children go ahead. The go ahead to continue living on the land, which the children would eventually have, would not have its authority from the will which the deceased wrote and then disposed the properties to his children. That is not where the authority is coming from. Because the children cannot rely on that authority by saying, our father gave us the property, therefore the property is ours. No, your father did not have the property in the first place. Therefore, your father cannot give you the ownership of something that he did not have. the only person that can give you is A. And then A, through the family members, can say, okay, oh, your father was a very good man and he gave birth to very good children, and because of that, we are going to let you continue living on the land. Boom. Or they will say, oh, we want to use this land for something else in relation to the family. Come and use these other sets of land for your possession and all that. Boom. Do you see that? Now, I've told you, he can't sell the land to a third party. He can't give the land in his will to his children. And also, he cannot use the land as a collateral for personal debt, as was stated in the case of Jacobs versus Oladuni brothers. You cannot go and say, okay, let me go to the bank, I'll drop the land as a collateral for loan and all that. You cannot treat the land as if it were your personal property, because it is not yours. Nemo dat quod non habit. You cannot give what you don't have. Do not forget that. And let us go to more rules in relation to the notes. Furthermore, the member cannot in his will pass the family property to persons who are not heirs directly. In the case of Ogumefon versus Ogumefon, where a testator devised her share in a family property to certain relations, it was held that the disposition was void, and this rule was also stated in the case of Taylor versus Williams. A member is entitled to exclusive enjoyment of his allotment for the purpose for which it was granted, and any attempt by the head of the family to disturb his quiet enjoyment may be actionable in trespass. This was held in the case of Agbohe versus Sapo. And also, where a fellow member disturbs, the member in possession of the land can sue for trespass as well. And this was stated in the case of Oko versus Olotu. So basically, we've learned the rules in relation to the rights that the member has. The member has a right of allotment, and that right of allotment only gives rights of possession, not rights of ownership. And also, even the family head, when the family head wants to disturb his quiet possession on that land, on that particular land that he has been given, even though by the family head, that would amount to what? Trespass. Either the family head or any other family member that wants to disturb his quiet possession. So far, that particular allotment was made validly by the family head. Do not forget, as I've stated in my other land law videos, I told you that B and C, not being the family head, cannot single-handedly allot land to other family members. Nah, it's not possible. Do you understand that? This is the person that can allot. Do you understand that? And now when this person has exercised his right of allotment and has allotted, let's say, C, a land, he cannot come later and start disturbing C on that land. It's not possible. Until C dies, C has a right to quiet enjoyment of his land for whatever the purpose of that allotment has been for, which is most times for possession and quiet enjoyment. Do you understand that? So with this, we've learned a lot in relation to the nature of members' right in relation to the right of allotment. In my next set of land law videos, I'll be talking about sale of family property and other rights that members would have as well as family heads, the improvements on a land, whether or not when a person has improved a land, we can say that that person is therefore the owner of the land. You know, we have several authorities for that, Sate Gandekwa and all that. Now, in my next series of classes, land law classes, I'll make sure that I touch little parts of this one after the other. Don't forget to click the subscribe button. Don't forget to click the notification bell, and more importantly, don't forget to like this video, and also do not forget to follow me on LinkedIn. I hope you enjoyed this class. I will see you in next subsequent set of classes. Have a beautiful day.